The rift brewing amongst ex-bandmates of the defunct pop boy band Plantation Boys takes another dimension. Amedu Augustine, better known as Blackface, has warned his former friends and bandmates Tubaba and Faze not to perform songs recorded by the group. Blackface, who has been embroiled in a widely publicized altercations with Tubaba on copyright issues for some time now, reportedly got his lawyers to serve his ex-bandmates a notice of an impending copyright violation ahead of a scheduled concert tagged the Foundation Concert and Awards, put together by rapper Rugged Man. In another statement, Blackface categorically stated, and I quote, "Performing any of Plantation Boys' songs at the said concert would amount to an infringement on my registered copyright. Tubaba or Faze shouldn't go there and perform any song by the band because copyright over the songs belong to the band and not an individual." End of quotes. While we continue to monitor how this will eventually play out, we are now being joined over the phone by copyright attorney Olumide Mustafa to help us understand how this can swing in the court of law. Now, many thanks for joining us, Olumide. Now, how tricky is the situation right now?
In answer to your question, the situation is seeming to get more serious now that we have a solicitor's letter from Blackface's solicitors. But the confusing picture has been arising primarily due to Blackface's prior posts and the complaints he made in those posts. Generally, the posts seem to conflate issues of copyright and image rights complaints. So he would complain about his music or the music he claims is his being used. And then he would also mention things like performances adversely affecting the image and brand of the name Plantation Boys. But since we have the solicitor's letters now, which is actually what has now propelled this matter further, that letter itself we can use as our guide. And since that focuses more on copyright, it seems that copyright is the main complaint and should likely be the main point of focus if the matter ever gets to court.
Now, we understand that the songs were recorded by the band, but can we assume that if two members from the group agree to come together to perform the songs, and that can form a quorum and they can go ahead to perform the songs?
Yes. In answer to this question, it seems that a few concepts are misconceived. There seems to be a confusion between principles more associated with company law and principles associated with copyright. Now, this is a copyright issue, as stated earlier, because that's what the complaint from the solicitors focuses on. Now, the question with copyright is always, firstly, who owns the relevant copyright. So in this case, it's a question of who owns the Plantation Boys songs and the recordings. Now, under Nigerian copyright law, the law states that where two or more people jointly compose a song, then unless there's an agreement between them otherwise, the default position is that they all have a joint equal interest or right in those songs. Now, to take it even further, our law also provides that, again, unless there's an agreement otherwise stopping this, the default position is that if there are joint or co-authors of or owners of a copyright, in this case a song, any of them individually or in a majority of them or just one of them alone is able to grant a license to the entire copyright work, and he or she won't even need the consent of the other composers. The only obligation on any person that does that is that they have to share any proceeds from that license they've granted. They have to share it equitably, meaning fairly, with all the other composers. That's the only condition. But aside from that, as long as they fulfill that, they're well within their rights in the law to be able to grant a license to use the copyright work. So, I mean, if you look at the solicitor's letter, it actually states, and I quote from it, that all the Plantation Boys co-authored numerous well-known songs together. I mean, that's what the letter says. The letter also says, of course, that Blackface is the sole writer of most of the released songs. So those are sort of conflicting facts. But I mean, Tubaba and Faze and Ruggedy Baba can all rely on that particular fact stated in the solicitor's letter, which is that they all co-authored numerous well-known songs together. So on that basis, that means Tubaba and or Faze, together or individually, are under Nigerian law empowered to grant a copyright license for those songs. So again, the question is who owns them, because Blackface also contends that he's the sole writer of a few songs. Now, if he's the songs of which he's a sole writer, if he can prove that in court, then of course he's able to prevent them performing those songs, because the other two band members don't have any rights in it. So I hope that clears it up a bit more.
But lastly, before I let you go, if they eventually perform Plantation Boys songs, would Blackface have claims to the proceeds from the performance?
Yes, well, in answer to this question, under Nigerian copyright law, Blackface would be entitled, as I stated earlier, if he's a co-author or a joint composer of the songs, he'd be entitled to an equitable share of any proceeds generated from the songs themselves. So from any licenses granted to the songs by either of the other bandmates. So the question is whether any proceeds that Tubaba and FaZe are going to receive from the show, are they for appearance fees or are they copyright license fees? Now, in general practice, copyright license fees for shows and venues, people that put on concerts, they're usually handled and administered by the collective management organizations. So that's COSON or MCSN. So a venue usually pays money to COSON or MCSN annually to allow them to have music played in their establishments. So it's very unlikely that the monies that Tubaba and FaZe will be getting would be related to the copyright. It would be more for fees for them to appear at the show. In that case, the money paid to them, Blackface wouldn't ordinarily have any claim to. Like I said, he'd only be entitled to any money that was generated related to the songs themselves. Appearance fees are governed by contract law as opposed to copyright law. So unless Blackface can show that he's entitled to claim from a contract that's between Tubaba and FaZe and whoever the concert promoter is, whether it's Roggedy Baba or a company or some other sort, there's no way he'd be able to establish a claim based on that. I hope that clears it up.
Now, many thanks again for joining us, Olumide Mustafa.